ago, few people had ever heard of Tsarnaev. Back then, he was just an average college kid maintaining a below-average GPA at UMass Dartmouth. But fast forward a few months, and the then 19-year-old was a household name, his image occupying the coveted cover of Rolling Stone magazine. Now, some 20 months after the Boston Marathon bombing, the sole surviving suspect is standing trial. Today, the defense and prosecution began winnowing down 1,200 prospective jurors to just 18. The 12 jurors and 6 alternates who could decide whether Tsarnaev lives or dies. At 9:14 this morning, Tsarnaev was led into a glass-paneled room inside the Moakley courthouse, where he faced hundreds of prospective jurors. Today's proceedings were a major setback for the defense, which says Tsarnaev can't get a fair trial in Boston and has repeatedly asked for a change of venue. But over the weekend, a federal appeals court rejected that request. Today in Boston, the people we spoke with were divided on whether a Boston area jury can try Tsarnaev fairly.
I think it's difficult for him to get a fair trial anyway. There was such publicity all over the world.
If I were in there, you would sit, you would listen to the facts, and you would make your decision.
I don't see how anyone in this area could not have been exposed to the widespread media attention, and it's just so dear to all of our hearts.
For his part, Judge George O'Toole says Tsarnaev can get a fair trial here. And today he told prospective jurors that if they're called, nothing they've previously learned about this case can affect their deliberations. Jury selection is expected to last several weeks, with opening statements slated for January 26th. Judge George O'Toole warned prospective jurors to avoid news coverage and refrain from discussing the trial. But some question whether it's possible to seat an impartial jury and for Tsarnaev to receive a fair trial here in Boston at all. Harvey Silverglade is one of them. He's a criminal defense attorney and renowned civil liberties lawyer. We're also joined by Don Stern, a former U.S. attorney from Massachusetts who prosecuted the likes of Whitey Bulger. Welcome to both of you. Harvey, let's start with you. You wrote a very tough op-ed for the Boston Globe saying, essentially, that it's almost impossible for Tsarnaev to get a fair trial here and that a change of venue and a delay are both reasonable requests by the defense. Why do you say that?
Well, the change of venue is much more important because I don't see how somebody who attacked an iconic institution, Boston, which is, of course, the century-old marathon, is iconic, if anything is iconic, and get a fair trial. How is it that people will not have deep-seated feelings? Even if the jurors don't know they have these feelings, I just don't, it's not in human nature for somebody to let that go, even if they don't realize they can't let it go. I think it was very unwise to have the trial here.
Don Stern, I know you disagree. Why do you think what Harvey believes is impossible is possible?
Well, knowing something about the fact that there was a marathon bombing, even caring a lot about the marathon, isn't enough to disqualify somebody as sitting on the jury. The test here is whether the jury can be fair and impartial. And people could bring to that process some strong views, but as long as they can separate some of those views and feel comfortable and honest in hearing the facts and making their own independent judgment, they can be qualified to sit on the jury. It's going to be hard. I'm not minimizing the fact that there is going to be a long process of not only the jury questionnaire, but individual voir dire of jurors. But at the end of the day, we're talking about finding 12 jurors and 6 alternates among 6 million people in eastern Massachusetts. That can be done.
Don, just for the non-attorneys in our audience, what does voir dire mean? Because I know this is a phrase we're going to hear a lot in the coming months.
It involves individual questioning of juries. The tradition in Massachusetts typically is that the judge asks the questions. Sometimes the questions are given or suggested by the parties, by the lawyers. Here, I suspect that there could well be some kind of a combination where the judge will ask some of the jurors, those that have been kind of pre-qualified, if you will, and then perhaps permit the lawyers the opportunity to follow up.
Harvey, what do you say to Don's suggestion that it actually is reasonable to ask prospective jurors to take everything that they have heard before, any opinions they may have arrived at, and as the judge did today, basically just say, you need to put those aside once you're in the courtroom and come to a verdict based on the evidence that you hear presented. Is that not reasonable?
I think it is humanly possible to put aside information you got from the press, because a lot of people think that a lot of what they read in the press isn't true anyway. So that's humanly possible. I don't think it's humanly possible to put aside the image of an institution of which you are part, the community of Boston and the environs, that institution has been attacked, viciously attacked. I don't think you can put that aside. Even if you tell the judge you think you can, I don't think they really can.
That's actually, as a non-attorney, that's something I've always been fascinated in, is the question of whether a juror's own statements about what they can and can do are reliable. Don Stern, if a juror says, yeah, I was scared during the lockdown in Watertown, say, but I think I could judge impartially in this case, or be an impartial juror. Is it credible to take a statement like that at face value, or is it appropriate to take a statement like that at face value?
I don't think it will be taken at face value. I think there'll be follow-up questions. There'll be some probing of other. Can you give us an example where you held a certain view and in the course of your experience you changed your mind? I think both parties will be looking for, is this a person who is so inflexible that they come with a preconceived notion one way or the other and can't change their mind, can't listen to the evidence. In my experience, the jurors, it is a little bit like a bubble. I mean, we shouldn't minimize the fact, to some extent, we underestimate the ability of the jurors who deeply care about doing the right thing and who respect a great deal that judge who sits up there and instructs them as to the law. We underestimate the ability and the willingness of those jurors to basically act as good citizens and to try to do the right thing.
Actually, hold that thought for just one sec. I want to take a look briefly at some of the charges that Jahar Tsarnaev is facing, just as a reminder of what the jurors are going to be reckoning with here. 30 different charges, 17 of which could lead to the death penalty. We see some of them up there. Harvey, you were going to say before I interrupted you.
I have great respect for the jury system. I think it's essential to our democracy, but I don't think you can expect human beings to do inhuman tricks like try to forget that the institution of which they're a part and the community of which they're a part was attacked, and that they in fact had to cower in their own homes while there was a search for the monsters out on the street. I don't think it's humanly possible.
Let's talk, shift gears briefly and talk about what strategy the defense might actually use in this case. What do you two expect the defense to argue as they try to avoid the execution of their client?
Well, judging by the media accounts, the focus seems to be on the penalty phase, and I think what the defense lawyers will be doing from day one, every question they ask, every witness, they'll be having in mind, how does this feed into and how does this support our theory of the case? So even, for example, if they introduce statements that the defendant may have made to law enforcement or to others, it will be they'll be looking to elicit information about that, and maybe about his relationship with his brother, which of course what the media is suggesting, and what is going to be kind of the theme, which is, how does this 19-year-old kid who went to a public high school in Cambridge become a defendant in probably the most horrific crime committed in Massachusetts history? I
think that the case is going to be tried from beginning to end with the penalty in mind rather than the question of guilt versus innocence. And I think every question asked of every witness, including the first phase, which is whether he was guilty or not, whether he did it or not, the defense lawyers are going to focus on the impact that the answer to the question will have on the jury's sentencing decision, which is the second phase. If he's convicted, then the same jurors sit in the second phase. I think that's what really this case is about. If the government announced tomorrow that they were not going to seek the death penalty, I think the defendant would probably enter into a plea bargain.
Well, and in fact, just to take Harvey's point one step further, the questions asked to the jurors, potential jurors, will have that in mind. There'll be questions, I can imagine, for example, a potential juror being asked, do you have an older brother? Have you ever been asked to do something by your older brother that you thought you didn't want to do, but you decided to do it anyway? All those, even those questions, even before the juror is seated, they'll be thinking about, how does this play out at the penalty phase?
All right, Harvey Silverglate, Don Stern, thank you both for being here. Appreciate it.